the oppression of occupation. 500,000 Palestinians in Gaza are at integrated food security phase classification level 5, facing starvation. This number is 4 times that in the whole world. In Gaza, Palestinians are dying by Israel's war. They are also dying from hunger and lack of medication, as Israel prevents the delivery of food and medicine in violation of international humanitarian law and in defiance of the provisional measures you have ordered. This aggression has to end and end immediately. Those responsible for it must face justice. No country must be allowed to be above the law. Israel is acting and has been allowed to act in complete disregard of international law. That cannot continue. The occupation is unlawful. It is inhumane. It must end. Yet Israel has been systematically consolidating the occupation. It is blatantly denying Palestinians' right to self-determination. Its illegal unilateral measures are creating new facts on the ground that are killing all prospects for peace. Settlements, illegal under international law, are growing in numbers and are spreading farther in occupied Palestinian land. The number of settlers has grown from 280,000 in 1993, when the Oslo Accords were signed, to over 700,000 today, nearly a 150% increase. Settler terrorism is a growing evil. Its victims are innocent Palestinians, their homes and their livelihoods. As the occupying power, Israel has a legal obligation to protect civilians, to preserve cultural and historical heritage, and to refrain from forcing demographic changes. It is constantly and intentionally violating this obligation. Israel is forcing demographic changes in the occupied Palestinian territory, destroying cultural and historical Palestinian heritage, confiscating and annexing Palestinian land, driving Palestinians out of their homes, their farms, their villages and their cities. It is illegally detaining thousands of children, men and women, and subjecting them to physical and mental torture, humiliation and abuse. Israel is violating the right of Muslims and Christians to freedom of worship. The Israeli government is severely restricting Muslims' right to pray at Al-Aqsa Mosque and is taking no real action to protect Christian priests from humiliation and abuse by Israeli extremists. Throughout decades of occupation, Israel has been working on changing the Arab, Muslim and Christian identity of the holy sites in occupied Jerusalem. Mr. President, members of the Court, peace is the right of all peoples of the region. But there can be no peace until occupation ends. There can be no peace until the right of the Palestinian people to self-determination is realized by the establishment and global recognition of an independent, sovereign Palestinian state with East Jerusalem as its capital on June 4, 1967 lines that can live side by side Israel in peace and security. The Hashemite Kingdom of Jordan has been relentlessly working for peace. We have suffered the consequences of conflict. We know the value of peace to us, to the region and to the world, and we know what it takes to achieve peace: the end of occupation and justice, freedom and statehood for the Palestinians. The two-state solution must be implemented, and the Palestinian state must be recognized and accepted as a full member of the United Nations. And for the sake of peace and justice, Jordan will not relent in its effort to defend Muslim and Christian holy sites in occupied Jerusalem and to preserve their identity, as we shoulder our responsibilities under the historical Hashemite custodianship of the holy sites and the special role the Kingdom has towards them. Mr. President, members of the Court, Palestinians are being killed in the hundreds every day in Gaza and in the West Bank because Israel is not being held accountable for its war crimes and violation of international law. Children are undergoing surgery without anesthesia. 6-year-old Hind was left in the car for days next to the decaying bodies of her relatives whom Israel has killed. When medics finally arrived to rescue her, the Israeli occupation army killed them and killed her. This brutality that tortured and killed Hind is a constant reality of life under the Israeli occupation. No more. Rule that this brutality can be no more. Help deliver justice. Rule that the Israeli occupation, the source of all evil, must end. Thank you, Mr. President and members of the Court, and with your permission, I now yield to Dr. Ahmed Ziyadat, Jordan's Foreign Minister.
I thank His Excellency Ayman Safadi. I now give the floor to His Excellency Ahmed Ziyadat. Your Excellency, you have the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the Court, it's an honor to appear before you on behalf of the Hashemite Kingdom of Jordan. There are 3 sections to my address. First, I will identify in overview Jordan and the Hashemite family's special role and interests in the Christian and Muslim holy site in Jerusalem for more than 100 years. Second, I will share my reflection of the more than 3,000 pages of evidence placed before the Court on Israeli violations. Third, I will briefly identify consequences of the Israeli violations. Jordan's written submission and evidence that have been placed before the Court on these matters are adopted herein. Mr. President, members of the Court, Jordan and the Hashemite royal family have a special role as the custodians of the Muslim and the Christian holy sites in Jerusalem. This special role is of paramount importance to the whole world because it is what keeps the peace and preserves the historic status quo at Jerusalem holy sites. Jerusalem is holy to Muslims, Christians, and Jews, who together make over 55% of world population. And it must be a city of peace. Preserving the historic status quo is the key to that peace and to containing global religious tensions. In performance of this role, Jordan administers the affairs of the Muslim holy sites in Jerusalem, including their maintenance and restorations. Jordan also takes all measures within its power to protect both the Muslim and the Christian holy sites. This special role is historic and internationally recognized, including by the US, the EU, Russia, the UK, the Vatican, the Islamic States, and Israel itself. I will briefly highlight its recognition by some of the most directly concerned states and bodies. The final declaration of the Joint Arab-Islamic Summit held this year states, I quote, "The blessed Al-Aqsa Mosque, with its entire area of 144,000 square meters, is an exclusive place of worship for Muslims, and it is under the management of the Jordanian Jerusalem Awqaf, within the framework of the historical Hashemite custodianship of the Islamic and the Christian holy sites." Article 2.1 of the Jordan-Palestine Agreement of 2013 states, I quote, "His Majesty King Abdullah II, as the custodian of the Jerusalem holy sites, exerts all possible efforts to preserve the Jerusalem holy sites and to represent the interests of the holy sites in international forums and competent international organizations through visible legal means. Israel itself recognized Jordan's special role in the Treaty of Peace between Jordan and Israel of 1994. Article 9(2) of the treaty provides, in this regard, Israel respects the present role of the Hashemite Kingdom of Jordan in the Muslim holy shrines in Jerusalem. In 1924, the heads of churches in Jerusalem pledged allegiance to Sharif Hussein, reaffirming the Hashemite historic role in safeguarding and protecting Jerusalem holy places. The Hashemite kings of Jordan have performed that role ever since, and this allegiance has been repeatedly renewed. In 2013, His Holiness Pope Francis wrote to King Abdullah II to acknowledge His Majesty's custodianship. His Holiness stated, I quote, "I'm deeply conscious of His Majesty's internationally recognized role as custodian of the holy places of Jerusalem. The care of the holy places of Jerusalem has always been the highest priority of the Hashemite royal family. Turning to violations, Mr. President, members of the Court, I will share a few examples of Israeli violations in the holy sites since its occupation of East Jerusalem in June 1967. In June 1967, within days of its occupation, Israel demolished the historic Maghrabi Quarter, consisting of 153 houses, and expelled its residents in order to enlarge the space in front of the Al-Buraq Western Wall for Jewish prayers. Further, the Maghrabi Gate pathway, an ancient earthen ramp leading to Al-Aqsa Mosque, was demolished in 2004 and replaced by a wooden ramp in 2005. A serious and more serious violation that has been going on for decades is the extensive and systematic digging and tunneling works around and underneath Al-Aqsa Mosque, which threatens its structural integrity. On the 10th of September 2023, a UNESCO decision criticized Israel for failure to cease these activities and described them as persistent and illegal under international law. In April 2020, during the holy month of Ramadan, the Israeli forces raided Al-Aqsa Mosque during dawn prayers and attacked Palestinian worshippers with rubber bullets, stun grenades, and tear gas, causing more than 100 injuries to more than 100 people and made more 400 arrests. In the same month, the ancient Kibli Mosque was subject to a similar attack, and significant damage was caused to historic glass windows, the minbar, and the carpet. On December the 13th, 2021, and on March 31st, 2023, the patriarchs and the heads of churches of Jerusalem issued a statement expressing their concern that Christians and their holy sites have become the target of frequent and sustained attacks by Jewish radical groups with the aim of diminishing Christian presence. Mr. President, members of the Court, Israeli violations in the Muslims and Christian holy sites violate the rules of international law, including Articles 27, 53 of the Fourth Geneva Convention, as we have stated in depth in our written statement. Furthermore, Israeli violations of the historic status quo at the Muslim Christian holy sites in Jerusalem threaten their integrity. They inflame global religious tension and create confrontations along religious lines. Mr. President, members of the Court, thank you for your attention, and I now request that you invite Sir Michael Wood to the podium. Thank you.
I thank His Excellency Ahmad Ziadat. I now give the floor to Sir Michael Wood. Sir, you have the floor.
Thank you. Mr. President, members of the Court, it's a great honour to appear before you and to do so on behalf of the Hashemite Kingdom of Jordan. Mr. President, Jordan fully maintains all that it said in its written statement and comments, including the conclusions, and I respectfully refer the Court to those pleadings for details of our position. In the time available, and given the hour, I shall be very brief in addressing 6 points. First, a small number of states have suggested that, giving its opinion, the Court should take care not to undermine the negotiating framework. Yet both in its 2004 opinion and in Kosovo, the Court rejected in no uncertain terms the argument that an advisory opinion could have a detrimental effect on negotiations. Your case law confirms that it is not for the Court to substitute its own views for those of the General Assembly on whether an advisory opinion may have such an impact. There is, moreover, no basis for making such an assessment in the present case. On the contrary, as the Court itself said in 2004, any negotiated solution must be achieved, and I quote, on the basis of international law. My second point concerns the right to self-determination. This right is well established in customary international law and is a norm of jus cogens, from which there can be no derogation. It goes hand in hand with the obligation to respect the territorial integrity of the self-determination unit, as well as the right to permanent sovereignty over natural resources. The competent organs of the United Nations have affirmed this right repeatedly over the years, demanding the establishment of a Palestinian state and the realization of the two-state solution. Regrettably, Israel's occupation has now lasted for well over half a century. During this period, Israel has intentionally breached fundamental principles of the law of occupation. The raison d'etre of these breaches is to deny the right to self-determination of the Palestinian people. The occupied Palestinian territory has been progressively fragmented. Its demographic composition has been and continues to be altered. Settlements and outposts expand rapidly, while the Palestinian people's access to natural resources is denied and water resources are depleted. All this, Mr. President, members of the Court, severely violates the Palestinian people's right to self-determination, including their right to an independent state on the 4 June 1967 lines, with East Jerusalem as its capital. The only way, Mr. President, for the right to self-determination to be exercised is for the occupation to come to an end. Turning to my third point, Israel's policies and practices also violate the law of occupation, which applies throughout the occupied Palestinian territory. Israel has engaged in a policy of progressively establishing settlements and so-called outposts. Israel's 2018 Basic Law declares, and I quote, "The state views the development of Jewish settlement as a national value and shall act to encourage and promote its establishment and consolidation." As others have said, 2023 was a record year for settlement expansion. And just recently, in late January, senior Israeli officials caused for settlement of Gaza and for the expanding settlement in the West Bank. Israel's settlements have created a patchwork of territorial units throughout the West Bank. They seek to create facts on the ground, and they undermine the establishment of a sovereign, independent, contiguous and viable Palestinian state. As many others have said, they are often accompanied by brutal settler violence, tolerated or even supported by the Israeli authorities. One effect is to instill a sense of terror and fear in Palestinians, leading to displacement from their own land. This brings me to the fourth point. Israel's policies and practices, when considered in their entirety, leave no doubt as to Israel's intention to annex the occupied Palestinian territory. The facts speak for themselves. Israel's 1980 Basic Law, which purported to annex Jerusalem de jure, the continued construction of the wall in the West Bank despite the court's 2004 opinion, the scale, infrastructure and location of Israeli settlements, the expansion of Israel's direct civilian legal authority across the West Bank, and the continued displacement of Palestinians and the difficulties they face to return to their homes. If there were any doubt, the map shown by the Prime Minister of Israel before the General Assembly last September, which you've seen earlier this week, and his rejection of the two-state solution confirm Israel's intention to annex. The annexation of any part of the occupied Palestinian territory is a serious breach of the prohibition of the acquisition of territory by force, a peremptory norm of general international law. Mr. President, my fifth point is that Israel's discriminatory laws and practices severely affect the lives of Palestinians and demonstrate a total disregard for the occupying power's duty to protect the rights and well-being of the Palestinian people. Specifically, the policy of discrimination constitutes a serious violation of treaty obligations and of customary international law, tantamount to apartheid. The Third Committee, the Human Rights Committee, and the Committee on Economic, Social and Cultural Rights have each urged Israel to amend the 2018 Basic Law so as to eliminate its discriminatory effects and to ensure equal treatment of all persons within the territory and subject to its jurisdiction, within its territory and subject to its jurisdiction. This has not been done. Discriminatory expropriation laws have been supplemented by a vast catalogue of military orders that have little or nothing to do with security or public order. Instead, they permit discriminatory treatment in practically every aspect of daily life, a discriminatory planning regime in which permits are routinely denied to Palestinians, the discriminatory practice of demolitions, and the use of zoning to designate military areas or so-called nature reserves, access to which is either denied to Palestinians or subject to Israeli permission. All of this is backed up by increasingly frequent interventions by Israeli armed forces to suppress protests, often with lethal fire, by the apparent impunity of those who engage in violence against Palestinians, by the use of excessive force, by attacks on health services, and by the ever-increasing arbitrary detention and ill-treatment of Palestinians, including children. Further, as explained in our written pleadings, Israel has engaged in acts that constitute crimes against humanity and has failed to prevent and punish such crimes. Mr. President, members of the Court, I now turn to question B and to my sixth and final point. What the General Assembly asks you to determine is whether the occupation as such is unlawful. Three essential principles should guide the Court in responding to question B. These principles are fundamental to the law of occupation, and they reflect Jus Cogens norms. First, occupation is by its very nature temporary. It must not become permanent or indefinite. Second, the occupying power cannot acquire sovereignty over the occupied territory, whether by annexation or in any other way. Third, the occupying power has the duty to respect the right to self-determination of the people of the occupied territory, as well as all their human rights. Israel's occupation contravenes each of these fundamental principles. Israel's policy of settlements, including the transfer of settlers, the confiscation of land, and the forcible displacement of Palestinian communities, evidences Israel's intention to occupy permanently and to annex territory that belongs to the Palestinian people. Israel's serious breaches of the right to self-determination, the principle of non-acquisition of territory by force, and the prohibition of discrimination, all Jus Cogens norms, leave no doubt that the occupation as a whole is unlawful. The occupation is being carried out for purposes contrary to international law. Mr. President, I now turn to the legal consequences arising from the unlawful occupation of the occupied Palestinian territory. A principal consequence is that Israel must end its occupation of the whole of the occupied Palestinian territory, that is the West Bank, including East Jerusalem, and Gaza. This must be done, as we said in our written pleadings, as a matter of urgency and as rapidly as possible. Another legal consequence is that all states are obliged not to recognise the unlawful situation created by Israel's policies and practices, and not to render any assistance that may serve to further those policies and practices. The content of these obligations was set out by Palestine on Monday in some detail. States must, moreover, cooperate with the competent organs of the United Nations to bring the unlawful occupation to an end. A further obligation binds states to investigate, prosecute and punish any individual subject to their jurisdiction for grave breaches of the Geneva Conventions and crimes against humanity. The United Nations, and especially the General Assembly and the Security Council, must take measures to end the illegal occupation, taking due account of the advisory opinion to be given. Before concluding, Mr. President, I must emphasise, in the light of what some others have said, that until Israel withdraws from the occupied Palestinian territory, it remains obliged to respect in full international humanitarian law and international human rights law. Israel's obligations under these bodies of law continue to apply, even though the occupation as such is unlawful. Mr. President, members of the Court, that concludes Jordan's submissions, and we thank you for your attention.
I thank the delegation of Jordan for its presentation, which brings to a close this morning's hearing. The Court will meet again this afternoon at 3 p.m. to hear Kuwait, Lebanon, Libya, Luxembourg, Malaysia, and Mauritius. The sitting is adjourned.